All right, let's jump right in. Welcome to this explainer. Today, we're diving into the pretty fascinating world of real property law. We're going to put on our investigator hats and learn how to scrutinize property transfers exactly like legal detectives. The goal here, to look right past all that dense, fancy legal jargon and uncover the actual truth of who owns what.
Here's our briefing for today. We'll be covering deed versus title, the anatomy of a deed, types of deeds, the recording process, and finally, we'll wrap up with a solid deed review framework.
Let's kick things off with Section 1, Deed versus Title.
Okay, we've got to start by separating the physical piece of evidence from the actual legal concept of ownership. And to do that, we need to bust a really common misconception right out of the gate. Ask yourself, is a recorded deed magic? Honestly, a lot of people kind of act like it is. But to reality, a deed isn't suddenly powerful just because somebody typed it up using archaic language or got it stamped down at the county office. It absolutely does not automatically defeat liens, it doesn't cure past defects, and there is no way it's immune to being challenged in court.
So, what is it really? Well, a deed is simply a legal instrument used to transfer an interest in property from a grantor, that's the person giving the property, to a grantee, the person receiving it. And sure, while it's the central document in real property law, a deed actually only acts as evidence of a transfer, which means it has to be rigorously tested. Look, just because you hold a piece of paper that says you own the Brooklyn Bridge doesn't mean you actually own the Brooklyn Bridge, right?
Think of it like this. The deed is merely the vehicle of transfer. It's the delivery truck driving down the highway. The title, on the other hand, is the cargo. It's the actual legal status or ownership interest being transported. And this brings us to the golden rule of deed law. A deed literally cannot convey more cargo than the grantor actually has the authority to load onto the truck. If the grantor has zero interest in the property, well, that deed transfers exactly nothing.
Moving on to Section 2, Anatomy of a Deed.
Now let's grab our magnifying glasses and look at the clues hidden within the physical document itself. A serious investigator doesn't just skim the paper. You've really got to interrogate the essential elements, like who exactly are the grantor and grantee? Did the signer act individually, or were they acting in a specific capacity, like, say, an executor? What are the exact words of conveyance? You have to check that legal description, hunt for any exceptions or mineral reservations, and verify those signatures and the notary acknowledgement. You're basically looking for concrete proof that the person signing actually possessed the capacity and the authority to do so.
Section 3, Types of Deeds. Next up, we need to line up our suspects. We do this by examining the specific promises, or frankly the lack thereof, that different deeds hold. A warranty deed? That offers the absolute strongest promises about the title. The grantor is flat out warranting that they have the right to convey it and they'll defend against claims. Then, right in the middle, we have the special warranty deed. You see this a lot in commercial or bank-owned sales, where the grantor only warrants against title defects from their specific period of ownership. And then, the quitclaim deed. This transfers only whatever interest the grantor has right this very second. Even if that interest is absolutely nothing, it guarantees zero protection against liens or title defects. None.
You know, we also run into deeds involving trusts, and these require a whole extra layer of scrutiny. When you're dealing with deeds into or out of a trust, the specific phrasing on the document is absolutely crucial. If you see something like Jane Smith as trustee, you've got to realize that the title trustee alone proves nothing. A trust doesn't own real estate merely because a trust happens to exist. To verify that transfer, you have to verify the actual trust instrument, the trustee's appointment, and whether they even had the fiduciary authority to make the sale in the first place.
And similarly, we have legal process deeds, like sheriff's deeds and foreclosure deeds. Now these are not your ordinary private sales. They're the end result of a lengthy legal process. So if you see one of these, remember that the deed is only as strong as the court judgments, the statutory procedures, and the foreclosure notices behind it. A sheriff's deed doesn't magically prove that the underlying court judgment was bulletproof or that all prior liens were wiped out. You absolutely have to go check the court record to know for sure.
Let's jump to Section 4, the recording process.
Let's look at the public record and maybe interrogate that illusion of safety it sometimes provides. Here is the absolutely crucial point. A local recorder's office basically acts as a giant public notice board. Recording a deed gives the public visibility and constructive notice of the transfer. But, and listen, this is a massive but, simply indexing a document there does not magically make a defective, forged, or unauthorized deed valid. A recorder's job is to accept documents. They do not sit there and adjudicate their absolute legal perfection.
Because recording doesn't cure defects, you have to keep your eyes peeled for common red flags. We're talking about a wrong grantee, a missing exhibit, a deed signed by an executor before they were officially appointed, or maybe an unreleased lien. Let me be perfectly clear. These aren't just little typos. They are ticking time bombs. A simple defective notary acknowledgement or an unauthorized signature can quickly spiral into a major title defect, a halted sale, and some incredibly costly litigation down the road.
Bringing us to Section 5, Deed Review Framework.
Finally, let's equip you with a highly actionable framework to review literally any property transfer. By methodically grouping your analysis into these 6 steps, you really protect yourself. Step 1, figure out what kind of deed it is and precisely what property is described. Step 2, identify the parties and their capacity. Step 3, verify where the grantor actually got their authority. Step 4, check what warranties are actually being promised. Step 5, pull the recording info. And Step 6, actively hunt for any inconsistencies. Using this exact framework, you interrogate the document's history and spot missing information way before making any legal claims.
Let's see how this plays out in the real world. Applying this framework is vital. For example, say someone records a quitclaim deed to themselves from a complete stranger who never owned the property. Well, the framework tells us the grantor had 0 interest, therefore the deed conveys nothing, period. Or take a homeowner deeding their house into a family trust. The deed might be perfectly recorded, but that transfer, it does not erase their existing mortgage. That mortgage absolutely survives the transfer.
Which brings us to the ultimate takeaway of this explainer. Real deed analysis requires intense critical thinking. You must learn to treat deeds as evidence in an ongoing investigation. Do not just skim the text. Do not assume authority, and most importantly, never, ever rely on the title or the label alone without reading the entire legal instrument.
So now that you're armed with this framework, I want to leave you with a bit of a challenge. Think about your own home, or maybe a property you know really well. Are you ready to investigate your own chain of title? Take a closer look at the public land records in your county. You might be incredibly surprised by the hidden legal stories the evidence reveals. Thanks so much for joining me for this explainer, and happy investigating.